You may be seated. Good afternoon, everyone.
Good afternoon.
There's been some concern as to whether or not this matter is going to be aired or streamed. Let me inform everyone that it is being streamed on ETV, as is the case with all of our oral arguments. It will also be videoed and placed on our website within 30 minutes of the conclusion of this hearing. Mr. Attorney General, it is your writ, or at least a request for one. If you don't mind, before you get started, I do have a question for you. I'll let you put your name on the record, please.
Alan Wilson for the state, Your Honor.
All right, Mr. Wilson, my first question to you, and it's one just a procedural question for us, and one that we must inquire about in every proceeding, standing. You as a representative of the state and Mr. Gibson, the local solicitor, is your representative. He consented to this matter. How is it that you have the authority or the right to come in and complain about it?
Well, first off, Your Honor, this court always has the jurisdiction to consider jurisdiction in these matters. So, yes, Mr. Gibson was the circuit solicitor for the 5th Judicial Circuit, and in this particular statute is the circuit solicitor who has the authority to petition a circuit judge to file for this potential matter. However, in the Attorney General's office, we're the only actual office that still has an open case. A PCR appeal is still pending for Mr. Price. So it is our position that the state has standing to challenge the jurisdictional challenge that the jurisdictional requirements were not met by the 5th Circuit Solicitor's Office and the respondent in this particular case.
Well, now, this is not a PCR hearing, Mr. Attorney General, as you well know. So, again, the question remains, how do you get here?
Well, Your Honor, we've asked for this.
We all agree that this is a serious situation. It is a very serious situation. But there are things and rules, if you will, that we have to comply with as well. And standing, as you well know, is one. Not saying you can't come, you don't have standing, but I'm asking you to tell us why you should be allowed to now complain about something that you agreed to before.
Well, Your Honor, we never agreed to anything.
Oh, excuse me now. The solicitor is a representative of your office as well, is he not?
No, the state is the state is the state, Honor. We always acknowledge that.
So the state is the state is the state, and that includes you and Mr. Gibson being one and the same as it relates to prosecution.
Well, sir, in this particular case, the state is not the state when it comes to filing this motion. We are the Attorney General's office. For purposes of enforcing the jurisdictional requirements of 1725-65, we have come before this court today to basically say that we firmly believe that no representative of the state, the defense, or any court has the authority to enter into a secret agreement that would ignore or circumvent laws and mandates and requirements duly passed by the General Assembly. We also believe that the defense, the state, and the court cannot enter into an agreement that violates the constitutional rights of victims. We believe that this court, by voiding the order that released Mr. Price, can send a powerful message to all of South Carolina that justice doesn't happen in the shadows and in the darkness. It happens in the light of day. We are here today because what happened on December 30th was an order was signed that did not have legal authority. The judge did not have jurisdiction to pass this.
In terms of our legal ability to act vis-a-vis your standing, what is the legal effect of the solicitor's mea culpa, albeit tardy, arguing and urging us to undo this situation?
The order is void on its face, Your Honor. We believe that there are three, when the General Assembly passed 1725-65 in 2010, they actually put, basically it's a general grant of authority that the General Assembly has given to the circuit courts to lower a sentence for a correctional inmate who has provided substantial assistance. Under that authority, they've said there are requirements that have to be met before the court has jurisdiction to issue an order. Under subsection C of 1725-65, there are three shalls: that you shall file a motion, that a copy of that motion shall be sent to the chief judge.
Right, and I think we'll get into the procedural requirements of 1725-65. But I want you to respond to the very narrow and discrete question about the effect, if any, of the solicitor's submission that's in this record asking us to undo this. It's the defendant's position that the solicitor was the driver of this mess. And the one who's the driver of it is now asking us to undo it by way of a submission to this court. What's the effect of that?
Well, the effect, I don't think, changes anything other than the fact that the order is void on its face. Judge Manning never had the
What's the
jurisdiction.
case law that says that? What's the case law that said order is void rather than voidable?
Well, the case, Your Honor,
It's not State versus Taub,
No, sir.
because a procedural defect renders a proceeding voidable, which presupposes
Well-
an appeal, not a late writ.
Well, Simmons v. State says it's well recognized that a sentence imposed without jurisdiction is going to be void on its face.
This is not a sentence.
Yes, sir, but there have been a number of cases where the court has voided a sentence when it was illegally granted. State v. Taub, State v. Sellers, which is an unpublished case with the Department of Corrections. But at the end of the day, the order actually violates two statutes passed by the General Assembly. And the first statute is a general grant of authority by the General Assembly
So
to a court.
your position, this is a technical basis to void the order without addressing who did what and when below. So this order is just perfectly void, so perhaps there are other orders that have downward departures out there in the weeds, and if you go looking for those, you're going to bring writs of prohibition on those cases too?
Justice James, if we come into contact or we learn of orders that were issued in violation of the law, then yes, the Office of the Attorney General will bring these writs of prohibition. At the end of the day, it is important that 172565 and 16320, which is a specific sentencing statute, which was last modified in 2010, at the same time that 172565 was created.
No, sir. The mandatory minimum of 30 years for murder was in effect ever since 1995. The provision in 2010 that was amended in 16-3-20 was a very nuanced amendment. It's still left intact the mandatory minimum of 30 years.
Yes, Justice James, it's what the General Assembly didn't do. What they didn't do is they created a new statute modeled after, as respondent asserts, after Federal Rule 35, and at the same time, they went and they amended this, Title 16, the murder statute, and they didn't connect the two statutes.
Okay, is the General Assembly presumed to have knowledge of its own prior enactments?
Well, the respondent asserts that the General Assembly does. We certainly agree with
That's
the
that's the law,
Yes,
right?
sir.
Okay, so in 2010, when a specific statute was enacted, 17-25-65, that said in certain circumstances, a sentence can be reduced, correct?
Correct.
And the legislature had knowledge that there was a mandatory minimum of 30 years for murder, mandatory minimum of 10 years for armed robbery, 15 years for burglary first, and on and on. It didn't say, provided, however, there shall be no downward departure below a mandatory minimum, did it?
I'm sorry, I don't understand your question, Justice James. In 1725,
1725-65, the legislature could have said, provided, however, there shall be no downward departure below a mandatory minimum.
well, Justice James, 1725-65 was modeled on the Federal Rule 35, which does allow for a downward departure and a reduction below a mandatory minimum, and the General Assembly omitted that provision from 1725-65. So you couple that with the fact that they didn't couple anything in 16-3-20, tells you that the General Assembly did not intend for a downward departure below a mandatory minimum of 30 years to life. That is the state's position. They knew.
So it could be reduced to 30 years.
Actually, we take the position that it can't be reduced at all, because when you look at 16-3-20, the murder statute, in 1995 till 2010, it read basically the mandatory minimum was 30 years. They added to life after it, which means now whatever a judge sentences someone to, the new mandatory minimum is somewhere between 30 and life. So if it's 35 years.
That's a fair point. That's a fair point. But I want to get back to the Chief's question and Justice Kittredge's question. The order, we know from the emails that that is the final revision that Mr. Gibson related or emailed to Mr. Rutherford. Why didn't he object? Why didn't he say, no, I'm not going to agree to time served? He could have done that as a representative of the state of South Carolina. He could have done that. Correct?
Justice James, I can't speak for Solicitor Gibson.
He's here.
I understand that he's here. I can't speak for Solicitor Gibson. I only learned about this last Monday. What I can say is that the jurisdiction in 1725-65, a circuit judge or a chief judge only has jurisdiction to issue an order reducing a sentence if those first two requirements are met.
Well, my disagreement with you is on the word jurisdiction. I disagree that this invokes the subject matter jurisdiction of the General Sessions Court. What I'm looking for is something else that is a hook to either send this back or void it.
Well,
It's not a question of jurisdiction.
16320, which is the murder statute, says it's a mandatory minimum sentence between 30 years to life. And within that subsection of 16320A, it says no good time credits, no work credits, or any other credits can reduce the sentence below the mandatory minimum between 30
But this
years.
is not a good time credit nor any other credit.
Well, it is reducing the defendant's sentence below the mandatory minimum. The General Assembly said mandatory
That
minimum.
statute specifically references existing programs.
Well, it also, Your Honor, that is true. It says existing programs, but it also says, nor is the person eligible to receive any work credits, education credits, good conduct credits, or any other credits that would reduce the mandatory minimum term of imprisonment for 30 years to life required by this section.
So you consider a reduction in sentence as a credit. I assume that's your argument.
Yes, Your Honor, but also, I would also say that the General Assembly, when they passed this reduction statute, this general grant of authority, they omitted the very language that the federal Rule 35 uses, which allows you to go below a mandatory minimum. They didn't put that in the law.
If they were conscious enough to admit that language intentionally, then they would have been conscious enough to include something in this statute that would preclude this kind of a situation, wouldn't they?
Your Honor, it is the position of the state that the specific sentencing statute of 16320 would trump the general grant of authority.
Well, Mr. Wilson, we don't argue with you about the statute. We're looking for you to give us some authority to do what you're asking us to do. All you're doing is just saying this is a bad thing. Do something about it. That's a mess that y'all made, and you're asking us to clean it up without giving us grounds to clean it up.
Well, Your Honor, if a court doesn't have jurisdiction to enter into an order.
Well, I agree with Justice James. This is not a jurisdictional question.
If your argument about 16320, how important is that 16320 trumps 1725-65? How much weight do you give to that argument in terms of your jurisdictional approach? Does your jurisdictional argument hinge on the threshold finding by this court that you're correct, that 16320 trumps 1725-65?
Well, I understand you said this is not a jurisdiction case. Notwithstanding what was just told to me, we've taken the position that both of these statutes stand independent of each other and support each other.
Stop. You've had two people tell you it doesn't. You hadn't had 5 people. So I'm asking you for my benefit. I'm trying to hone in on your jurisdictional argument. Is your jurisdictional argument confined to 1725-65 because the procedures were not followed? Or is it an overarching argument that it's that overlaid with the controlling feature of 163-20?
It's the latter, Your Honor. It is an overarching feature. I mean, the mandatory minimums are overarching, but the process that gives the court, again, I know some of you don't agree with this, but the requirements that give the circuit judge a jurisdiction to enter this order were not met. But even if I concede, which I'm not conceding, that jurisdiction isn't a point here, the mandatory minimums in 16320 trump in this case.
Let me follow up with you on that, I think that you can see that one thing we're wrestling with is how do we get to the result. And you're correct in your premise that clearly if there is no subject matter jurisdiction, you can raise that at any time. We've always said that in many different types of cases. And it is certain that before June 2nd, 2010, which is the effective date of 172565, is, in my view, tell me if I'm wrong, it's certain that no circuit judge would have had subject matter jurisdiction to reduce a sentence as was done in this case until this statute was passed. So you're arguing to us, I think, that because this is the statute that gives a circuit judge subject matter jurisdiction to reduce a sentence after it has been imposed and after the time for appeal has expired, because this is the jurisdictional vehicle, the predicates that are in the statute are actually jurisdictional. And if you're right about that, then we're there. We can get to the merits. The question that I think you're being asked is, if you're wrong about that, what if it's not a jurisdictional issue? How do we get there? And maybe misunderstanding Justice Kittredge's question, but it might have to do with the fact that the solicitor, who was the moving party to get this done in the first place, now has asked us to undo that order. Maybe that gets us there. But I'm not really asking you that question, but we are wrestling with whether or not it is appropriate for this court to come in and undo what could be, under the sort of general principles of law, a final order. And that's what we're wrestling with. But we got way off into the merits, and I'm sure we're going to spend a lot more time there and have a good time doing it. But that jurisdictional point is in front of us.
Can I follow up on some other things, Chief?
Yes.
Yes, you may.
The emails that are in the record that Mr. Rutherford attached to his filings show that the solicitor had the final draft of the order on December 30. It's an email at 10:16 a.m. that day. And the words were, I quote, "The final revision attached is the final revision that will be submitted to Judge Manning for signature." That's what the emails say. You don't dispute that that email was sent by the solicitor?
No, we don't dispute that,
All
Your
right.
Honor.
Who walked the order down the hall to Judge Manning's office? How did it get to his office?
I can't know that answer, Your Honor.
Don't know, but Mr. Gibson's here. All right, there is no qualifier in that email that says, I'm going to deliver this to him pending a hearing, pending victim notification, or pending me filing a written motion. There's nothing like that in there, is there?
Not to my knowledge, Your Honor, no, sir.
Do you agree there should have been?
Yes, sir.
Okay, so that goes back to the question that the state is in effect asking us to rescue it from itself, correct?
Well, Your Honor, the state is asking you to right a wrong that was done on December 30th.
That the state sponsored.
That is correct, Your Honor.
Okay, so your authority as Attorney General under the Constitution is to supervise all criminal prosecutions, correct?
Correct, Your Honor.
But this was not, at the stage it was on December 30, a criminal prosecution, was it?
No, Your Honor.
Okay, so what is your authority and with great respect, what is your authority to be here?
Well, Your Honor, as you just said, as the Chief Legal Officer and Chief Prosecutor of the state with authority to supervise
Criminal
all cases in courts
prosecutions. Criminal prosecutions.
But, Your Honor, the solicitors, they actually fall under the Attorney General in this particular case. I mean, we learned about this on the 17th, which is last Monday. What we learned is that the order that was signed on December 30th did not meet all the requirements that the General Assembly mandated must happen. 3 shalls in that code section: shall file a written motion, shall copy the judge, and then the jurisdiction shall be had by the court to hear and resolve the motion.
But it wasn't done.
The hearing never occurred.
All right,
Motion was never filed.
Let me ask this question. If this order, I was a circuit judge, as was everybody up here. Would I have signed this order? No. But it was signed. And it was not, the state did not appeal from that order, correct?
Well, we didn't know about it, Your Honor.
Well, now, Mr. Gibson knew about it.
Mr. Gibson knew about it, yes, sir.
Okay, he did not appeal. Had 10 days to appeal, correct?
Yes, Your Honor. But again,
And I know that a separate issue, go ahead, I'm sorry.
I was going to say that I don't think that 10 days would apply because the order is void on its face because they didn't file a written motion
Jurisdiction.
as compliant with Rule 4 of the Rules of Criminal Procedure, didn't file a copy, and they didn't have a hearing to resolve the motion from the first requirement.
Well, you have a sealed order with no hearing to seal it. It was never filed. Who knew it? Who could file an appeal? It's a phantom order.
You're taking the words right out of my mouth, Justice Kittredge. I mean, it was a phantom order. It was an illegal order. They did not follow the procedures required by the statutes that the General Assembly passed. The General Assembly is giving the court authority to do something, but they're saying if you're going to do this, you have to follow the requirements in the process. The solicitor's office failed to do that. The court signed the order anyway. The order is void on its face, but also it also is defeated by 16.320, which the General Assembly said you can't go below the minimum mandatory of 30 years to life.
Well, that's why perhaps the solicitor should not have engaged in the process at all.
Well, according to
But the fact is he did.
Well, 1725-65 says the solicitor and the
It says
jurisdiction.
the state. It says the state.
Let me.
I mean, there could be an argument that that once the conviction becomes final, that this is a statewide matter up to the Attorney General, not the solicitor.
And Justice Few, I'm reading, a motion made pursuant to this provision shall be filed by the circuit solicitor in the county where the defendant's case arose. So it is specific to the solicitor.
All right. I want to ask you about the fact that this was sealed, and what's the significance of that, and how that plays into perhaps it being a procedural and perhaps jurisdictional defect in the order. And to me, the starting point is Article 1, Section 9 of the Constitution that says that all courts shall be public, and then Section 14.5.10 of the Code that says the circuit courts herein established shall be courts of record, and the books of record thereof shall at all times be subject to the inspection of any person interested therein. And it seems to me that that's pretty clear. You can't seal the records of the Court of General Sessions, period. Or maybe I should say comma, unless there's another provision of law that permits it, such, for example, as the provisions of law that allow the grand jury proceedings to be sealed.
Right.
Or state grand jury allowing the circuit judge to provide that the indictments are to remain sealed until they're disclosed to the defendant. Or Rule 5 of the Rules of Criminal Procedure, which allows certain discovery materials to be sealed. Or ex parte funding orders in criminal cases, which by practice at least, if that's not implicit in the statute, are sealed until the trial is over. According to what I think is just common practice, when a defendant is tried in his absence, the sentence is sealed until the defendant is apprehended and brought back before the court. But other than those four provisions of law, are you aware of any other basis on which a circuit judge has the power to seal anything in the Court of General Sessions?
Not to my knowledge, Your Honor, and it was very unsettling that on December 30th, the order was sealed. I believe it was unsealed on the 9th, between the 9th and the 29th of March, and it was resealed again on the 29th after Mr. Price had been released from the Department of Corrections. It left a really bad taste in the mouth of my office and of the general public that's watching this case unfold. We feel like the rights of the victims were violated. I know that may not be the controlling thing, but under Article 1, Section 24, Paragraph 10, they have a right to be informed of all proceedings involving a release of an inmate. My understanding is they found out the day that the defendant was released from the Department.
Right, so those two can be intertwined, and what you're saying about the Victims' Rights Act is they're not just entitled to be notified that there's going to be a release. They're entitled to be notified that there's going to be a hearing, which of course there wasn't.
Correct.
All right.
And the respondent would argue there never was a hearing, therefore none of that other stuff needed to happen. We're saying a hearing is a necessary ingredient for the court to have jurisdiction to be able to even hear the case.
I have one more question. You can follow up on me, but about the sealing part. In the clerk's file that we received, and I assume that it's the same thing you received, there's a little sticky note. And the little sticky note has handwriting on it that says that we didn't clock this order because it was sealed. And to me, that is potentially significant because we have held in a wide variety of contexts that an order is actually not an order until it is filed. Now, whether the public record indicates that there was a notation in their case management system on December 30th showing that there was an order. But when you consider how it is that the order is going to be enforced, there's no clock, there's no stamp on it, there's no indication on the face of the order that it is actually an order. Somebody takes that, I guess, I don't know how this played out, to the Department of Corrections. How do they know that was a real order? So in other words, this whole secrecy thing and this whole whether it was actually filed thing, to me, plays very much into whether it is a legitimate order, and I wanted to get your comments on that.
Well, Your Honor, we also noticed that there was no clock copy of the order. That was also a little bit unsettling. What's also unsettling is, and this court's not here today to hear the merits of what was included in this order, but you've got unsigned and unsworn affidavits. You've got an addendum that's pretty much self-authenticating, saying the substantial assistance that Mr. Price allegedly provided. The one thing omitted from the supporting documentations is any record from the Department of Corrections that anything in these documents actually occurred or happened. That would have been great to know in a full hearing.
But we don't have an affidavit from the Department of Corrections why they accepted an unfiled order to set a convicted murderer free, do we?
No, Justice James, you don't. And again, I'll let the Department of Corrections speak for themselves. But at the end of the day, you've got an unstamped order with spacious supporting documentations. The process wasn't followed.
Well, talking about the affidavits, well, let me first ask this question. Who made the request to seal the record? A judge doesn't do that sua sponte. So who made the request? Did the solicitor make it?
Your Honor, I'm sure that, Mr. Rutherford, who will stand up here in just a few minutes, will be able to answer those questions. I'm not aware, because again, I wasn't there. We learned about this 10 days ago.
Is there anything in 172565, Mr. Attorney General, that would allow this motion to be ruled upon without a hearing?
No, Justice Hill, there isn't. It says in the first three sentences, motion shall be filed, copy of the motion shall be sent to the chief judge, and at that time, a chief judge or circuit judge shall have jurisdiction to hear and resolve the motion. So there would have to be a filed written motion.
And what Justice Few is talking about Article 1, Section 9, about all courts should be public. And all courts are presumptively public. And sentences, I know you said earlier this wasn't a sentencing, but it was basically a resentencing, wasn't it?
In a sense,
Okay.
yes, Your Honor.
But sentences that are against public policy are void, correct?
Yes, Your Honor.
Is that something you're relying on?
That is one of the many arguments we're relying on, Your Honor. And again, my time has expired. I can close with
we
this.
intend
We're
to
not
allow
done with you yet.
Okay. I knew this was coming, Justice Few. I began my comments, and again, it's not for the court's position to get into policy, but basically what's happening here is you have a representative of the state, the defense attorney, and a judge entering into an agreement. The judge ratifies the agreement through his signature, entering into an agreement that effectively violates the intent of the legislature from the laws that it passed. It violates 16.320 and it violates 17.25.65. If this court doesn't void, if there's no consequence to this, then all over the state, people can enter into agreements that violate the rights of victims, that violate statutory requirements and mandates passed by the General Assembly. The General Assembly was very specific, clear and unambiguous. You shall do these three things. That is the process that gives the circuit court jurisdiction to even consider a reduction in a sentence. Of course, 16.320 would defeat a reduction in Mr. Price's sentence because his new mandatory minimum pursuant to the 2010 amendment to the 16.320 murder statute is now 35 years, not 30.
Mr. Wilson,
Yes, sir.
just one question. I recall being a part of that commission that drew this. Now, I do recall that prosecutors came in and asked that 17.25.65 be a part of our report and now in the law. And the argument that you all, meaning prosecutors, gave was, we need convicted criminals to assist us in other crimes or preventing other crimes, and they need an incentive to do so. If we're going to say every mandatory minimum sentence cannot be reduced, and there are quite a few mandatory minimums out there, where does that put your request that we add this to the statute?
Well, Chief Justice Beatty, that's a policy question for the General Assembly. They have agreed with the prosecutors that you want to incentivize inmates serving in the Department of Corrections if they can provide substantial assistance or save a correctional officer's life, and they can receive a reduction in the sentence for doing that. General Assembly has no problem with that. What the General Assembly did do is it omitted the specific language that this statute was modeled on under the federal rule that allows you to go beneath the mandatory minimum. The General Assembly says people who are that violent and have committed those types of acts like murder should not receive that credit.
But
That might be a good
Mr.
argument.
Mr. Wilson, Mr. Attorney General.
Yes, sir.
I don't disagree with you at all. And I understand your position quite well. And to be quite frank with you, I'm a little taken aback by this myself. But the fact of the matter is that you all consented to it. Now you're asking us to undo it, but you're also you're asking us to look over the fact that this was done at your request, meaning this provision of the law, to incentivize criminals to assist you in other crimes, if you will, and now you're taking that away. I'm not saying that that's something that should not happen. I'm just saying that that's what you did.
Well, the order that Judge Manning signed came from the defense. It was a petition by them, and in the facts, number 3, it was upon motion of the solicitor, which the solicitor says in his press release actually was never formalized, and hearing was never held. So what we're asking this court to do is to recognize that the court could have never had jurisdiction.
I disagree with the jurisdictional question. You might not have had authority. There's a difference between jurisdiction and authority.
All right, Your Honor, he doesn't, well, according to the statute, and of course, I can't believe I'm arguing this point with the Chief Justice, but it does say shall have jurisdiction to hear and resolve the motion.
Well,
So,
they obviously didn't read
So-
our opinions about what jurisdiction is, but I'll leave that alone.
yes, Mr. Chief Justice, but at the end of the day, when you look at the 3 statutes or the 2 statutes and the constitutional rights afforded to the victims, and you harmonize those, you have a situation here where if you're going to do a downward departure and a reduction in the sentence, there needs to be an open, formal way so that the victims can be heard, so they can be notified and have a chance to address this issue on the court. They're entitled to that under our Constitution. That never happened to them because the 3 individuals in this case entered into an agreement. Judge Manning signed the order, and all of that stuff went away. The legal requirements for the process that would allow them to do this were ignored, the constitutional rights of the victims were ignored, and the mandatory minimums that the General Assembly specifically said in this particular case would apply to an individual like Mr. Price, it was violated. You could not go below 35 years, and they did.
I want to ask you a follow-up
I
question.
just got one final question. I'm going to leave the Attorney General alone. And I'm just want to point some things out. We're talking about the victims in this case and having ignored their rights. And I agree, they were ignored. But under the Victims' Rights Act, Section 24, it does not give the authority to undo a sentence because the victim was not notified of the hearing. It specifically says a victim's exercise of any right granted by this section is not grounds for dismissing any criminal proceeding or setting aside any conviction or sentence.
Well, Your Honor, I'm not saying that this is the provision that would defeat.
Just the point I'm making, it doesn't require you to respond.
Well, Chief Justice, if I may,
Yes, sir.
one of the reasons I mentioned the Victims' Bill of Rights is because it should be read in the context of a constitutional guaranteed right. That why would the General Assembly have this public process that's transparent, that affords people a hearing, that is harmonized with Article 1, Section 24, Paragraph 10 of the
agree.
Victims' Bill of Rights. Additionally, and again, I'll restate it again, 16.320, the General Assembly could have opened up the hood of that vehicle and tinkered with it and to make it comport with 1725.65. They chose not to do that. They left, in fact, if anything, what they did is they further strengthened our position because the new mandatory minimums aren't 30 years. It's whatever a circuit judge lawfully sentences someone to between 30 and life. In this case, the new mandatory minimum for Mr. Price is 35 years.
Thank you. I think Justice Few has a question.
Justice James.
And I think
Justice James as well.
Following up on this significance of mandatory minimums and how they interplay with 1725.65, it's from the specificity of your argument about the language of the murder statute as might be compared to some of the other mandatory minimums, I kind of gather that you think those could be treated differently. In other words, mandatory minimum under the drug statutes, which says that a defendant, I think it's the drug statutes that say the defendant must be sentenced There are some other statutes that say the defendant must be punished, and other statutes that say the defendant must be imprisoned. Those could be read differently than the murder statute in terms of whether or not 1725-65 gives the authority to a circuit judge to go below a mandatory minimum. And we would not have to reach that question. We would simply need to focus on the language of 16-320. Is that your position, or are you asking us to?
No, I mean, Your Honor, I would agree with that. Obviously, the court, in other cases, recognizing Taub but distinguishing it on the facts that there was no prohibition to lowering a sentence beneath the mandatory minimum. There's the Sellers case, which is an unpublished opinion we cited in our brief, and there's also the Taub case, which deals with the specificity of a sentencing statute related to the general grant of authority in another statute, and that the specific sentencing statute would trump the general grant of authority, meaning the authority that the General Assembly gives the court to do something would be constricted by the specific sentencing statute.
Right, but I guess what I'm getting at is some of these other minimum sentences are structured around what the circuit judge must write on the sentencing sheet and don't necessarily address how much time must actually be served. Whereas the murder sentence is written differently, and you've articulated reasons why you're saying it. There's a specific provision in there, no early release program can be used to reduce that sentence. I'm just wondering whether or not it is necessary for us to decide whether 1725-65 prohibits a judge following reducing sentence under that statute from going below mandatory minimums in a case like a drug case, as opposed to a murder case.
Well, in this particular case, we're being specific to the murder statute, Your Honor, but I know that in other cases, like I think it was State v. Taub, when it was a drug trafficking case, where they went below the mandatory minimum. So, I mean, it can be distinguished.
There are a few other questions for you. Justice James?
Well, go ahead. All right, I'll go. My main concern in this case is the absence of notice to the victims. That just hits you square in the face. But the fact remains that it wasn't Mr. Rutherford's responsibility to do that. It was the state's responsibility to do that, because that happens in all the cases. For example, bond modification. Got to have the victim notified to be here so the victim can chime in on a reduction of a bond, or a sentencing in a CSC case, or in a murder case. Victim notification is paramount, but the fact remains that it wasn't done, and now the question is whether you can come in and ask us to undo something that, in effect, you did not ask us to do in the first place. But I have a big problem with the victims not being notified. More fundamental question, is Mr. Rutherford's status as a lawyer legislator relevant to any legal or procedural defects that you have argued?
I'm not making what he does professionally an issue in this case, this specific case.
Because it seems to me that that has been a driving factor in forums other than the one here today. But he didn't exert any undue influence over Mr. Gibson, did he?
There is no evidence in the record that I've seen that he has, as the record I have right now, Your Honor. But again, the secrecy of this whole thing makes people look at this with great skepticism.
But the lawyer-legislator angle, you agree, is wholly irrelevant.
But in this court, it's all about the law, Your Honor.
All about the law. I just want to be clear on that. Thank you.
Well, and the publicly elected solicitor was the one who was driving this thing into the dark, too, right?
Yes, Justice Hill.
Okay. Chief Justice was talking about the Victims' Bill of Rights and the constitutional guarantee it affords. And he said something that is entirely correct, that the failure to comply with the Victims' Bill of Rights isn't grounds for setting aside a sentence. And that's very true. But here, my concern is not only that lack of notice to the victims, but it's the lack of notice to the public. And here, this underground order, there was no way for anyone to appeal it or review it within the time allotted under the rules to do so in the normal course of events. But the Bill of Rights for the victims gives the victims a right to file a writ of mandamus, doesn't it? To ensure compliance, and that's the highest writ known to law. And that's how important that was to voters when they put that in the Constitution. So isn't that something that we ought to be taking into account as well?
Your Honor, that obviously can be taken into account. The Office of the Attorney General sought a writ of prohibition because we thought it was the appropriate writ. We also titled our caption or any other extraordinary writs that the court deems applicable in this particular case. We know that you have that in your bag of tools to use. But at the end of the day, Your Honor, let me say this. The state failed. The state failed in this process. And I understand I'm the chief prosecutor of the state, but the Fifth Circuit Solicitor's Office failed to meet the statutory obligations under 1725-65 and to provide a public open hearing. Now, the sealing of the order, I don't know what happened, but I'm not trying to say the state is not at fault here. But in my position, as the chief prosecutor of the state, who has a duty to supervise solicitors, when I became aware of this, when our staff became aware of this, we reached out to the solicitor's office. We tried to find out as much as we could. We appreciate this court for unsealing this order. It gave us a little bit of sunlight to be able to make a decision on how we wanted to proceed, and we look forward to pursuing all of our other options on the table. But for purposes of today, we hope that this court, and we know that this court is taking this very seriously. Your questions indicate that you are. But we hope that when we walk away is we don't think that there should be an ability in the law for individuals like a judge, a defense attorney, and a solicitor, or an attorney general, myself included, should never be able to consent or enter into a secret agreement that violates the law and denies people their constitutional rights.
I want to ask you a follow-up question on that. It's really kind of following up to what I was asking you earlier. We talked about the Constitution. We talked about 14.510, and I listed four. There may be others that I didn't come up with, but there are specific provisions of law that would enable, under certain circumstances, a judge to seal something. And this is I mean, you need to think about this because it's going to come back and haunt you, your answer, in some other case. But is it true that in the Court of General Sessions, there is no inherent power in a circuit court judge to seal anything? Once we look at that constitutional provision, look at that statutory provision, there has to be some provision of law that allows a circuit judge to seal something. And there must be no recognition of inherent power to seal. Do you agree with that?
I do agree with that.
Thank you.
Well, Mr. Attorney General, we're going to allow you to sit down, but I think you should know from our questions here that we're very interested in this one. We don't want to be the basis or present the basis for bad law. We understand our decision in this case will impact cases in the future. And I imagine there are other situations just like this one that are out there that are unknown to you as well as us. And when we make a decision in this matter, we want to make the right one, not just for this case, but all cases going forward.
Thank you, Mr. Chief Justice.
Mr. Rutherford.
Gentlemen of this honorable court, Mr. Chief Justice, first of all, let me start off by saying that this was a proposed rule by the South Carolina Sentencing Reform Commission report to the General Assembly, proposed rule number 9, and it was meant to mirror the federal rule 35.
I'm well aware with that, Mr. Rutherford. I was part of that commission.
Yes, you were, Mr. Chief, and the Attorney General errs when he says that there's a sentence in it that specifically mandates that the federal courts can go below the mandatory minimum. He errs because he fails to realize that Rule 35 was put in 1946. It predated the mandatory minimums that were put in by the federal government in 1984, so it was added in 1987 because it predated, as in this situation where 1725-65 is predated by the murder statute defining the mandatory minimums. The General Assembly recognized, as the Chief stated, the Chief was on a panel. On that panel along with him was the current Speaker of the House, Merle Smith, along with at that time, the leader of the Department of Corrections, John Osment. They presented this to the General Assembly. There were a number of members that were also present from the Solicitor's Commission, from the Judicial Circuit, from Prosecution Coordination. Laura Hudson, I see her in the audience, she was present as well. Everyone had the ability to talk about what we were going to do, what the General Assembly was going to do. The General Assembly did not mention it. The General Assembly did not mention it because at the time, we were trying to deal with an exploding prison population. We were told by prosecutors that this was necessary in order to reduce the sentences of those persons that would cooperate, and believing, as in this case, that cooperation was necessary to effectively run law enforcement and to more effectively run the Department of Corrections. And that is why.
Well, that's great. That's fine. But why didn't the General Assembly include subsection B4 from Rule 35, which specifically grants a federal judge the authority to go below a mandatory minimum.
Because that was added, because it was after.
It was
remember, it was
before 2010, though.
It was, yes, it was before 2010.
And
but
the
it's not
General Assembly's
necessary.
looking, you're saying General Assembly's modeling their statute on Federal Rule 35, and Federal Rule 35, as it existed in 2010, included subsection B4.
Because the General Assembly recognized, as did the prosecutors, as did the judges that were there, that there was no need to add that because it was clear, because otherwise we would have added it, as we have done in multiple bills since then, in multiple laws since then, dealing with diversion programs, dealing with good time credits, dealing with house arrest, a number of statutes where we usually import 16160 to define what is a violent crime and what does not apply. Had we wanted it not apply specifically to murder, we would have said that. Had we wanted it specifically not apply to mandatory minimums, we would have said that as well,
You
or
have
just
to
use the
say
broad
they.
term 6160.
You're not we here, you're they.
I'm
They're they.
sorry, yes, sir. I've been there so long, it becomes and I apologize.
Let's say that 1725-65 is good law, no question. Given the complete lack of compliance with 1725-65, would you now join the solicitor and ask that we vacate the underlying improper order and allow for a new proper proceeding?
Unfortunately, I would not, and I would rely on State versus Hayward and others that allow the state, or in this case, the solicitor, or his step-in, the Attorney General, to keep the identity of confidential informants secret. What happened in this case was that Mr. Price gave information to the Department of Corrections that a very violent criminal who had escaped now for the second time, who had already committed a bank robbery, who had already committed a burglary, who had committed a home invasion and tied up a member of the audience at gunpoint and held him at gunpoint. That person had been gone for more than 2 days. The Department of Corrections had miscount again, and that
You may be able to talk for 2 hours about how wonderful this order was and how Mr. Price was entitled to it. But the law requires the filing of a motion. It was not done. Why was a motion not filed?
I would argue that it does not require the filing of a motion to begin the process. In fact, I would argue that the way the statute is written, with that coming at the end of the statute.
Rule 4 requires a motion, if in writing, if you don't do it in open court on the record, which didn't happen here either.
Or you put it in notice of the hearing.
Upon the state's motion made more than 1 year after the sentencing, direct quote from 1725-65. All right, a motion was not filed. 1725-65 requires the motion to be sent to the chief administrative judge. Judge Manning was not the chief administrative judge. Why was that not done?
Your Honor, I'm sorry, Justice, I can't speak for what the solicitor, because certainly these are guidelines given to the solicitor, but they do not preclude the beginning of 1725-65. That, we would argue, is precluded when the defendant acts to do something inside the Department of Corrections, which assists the Department of Corrections. And what I believe, and again, I can't speak for the solicitor or the Attorney General, in an effort to shield his identity, because he was still in the Department of Corrections, in an effort to shield his identity, that is why the proceedings appear to be secret. And a lot has been made under a sealed order. Sealed order was not meant to keep the justices from seeing it, the Attorney General, nor anyone in law enforcement. It was meant to protect the identity of someone that was still in the Department of Corrections in recognition that telling the world, and including the victims in this case, what had happened and who was involved, that it would put Mr. Price's life in jeopardy. And this court has recognized through case law, State v. Hayward, it is recognized through proposed rules that the identity of confidential informants can be kept secret by a prosecutor.
Well, that's.
I've got a series of questions, and I go down every requirement of 1725-65. There's not a single requirement in the statute that was satisfied. Not one. You want to talk about sealing the record. Davis v. Jennings, from 30-plus years ago, this court has held that when you want to seal a record, the court must make specific findings on the record which weigh the need for secrecy against the right of access and public openness. Where is that balancing and weighing conducted on the record in this matter?
Your Honor, I believe that that is what this court should find as to how the procedure should move forward in the future, or the General Assembly should decide how to do this when you have a case.
In the future in this case, or in just future cases?
In the future, using this case to give procedure when someone has given information that has been used by the Department of Corrections, and that person's identity needs to remain confidential. I do not believe, and I've looked, and that's why the Attorney General's office, I believe, continues to rely on TOB, which I don't believe applies here at all, because there is no case law in South Carolina as it relates to 172565. And because of that, no procedure for the solicitor trying to shield the identity of a confidential informant. So that is why it was sealed by the judge, and what moved forward from there. Again, not a secret proceeding. The solicitor was there, the defense attorney's there, and the judge is there. Simply a proceeding to try and shield the identity of someone that have cooperated with.
You're indicating there was a hearing.
I'm sorry, I don't mean to indicate that there's a
There was
hearing.
no hearing.
There was absolutely no hearing. Nor do I believe that one is required under 172565. And as it relates to the federal rules, the Federal Rule 35 constantly, judges are reducing sentences or giving downward departures without hearings. They simply receive notice that the defendant has provided information
We have a
and
statute,
act on that.
and the statute contemplates a hearing. And the Attorney General has gotten hit pretty hard today, because conflating him with the solicitor. The Attorney General has no authority under this statute to ask for a downward departure, only the solicitor.
That is correct.
You know, you're talking about there are numerous, did I interrupt you, Justice?
No, I
He was talking to me.
I was apologizing Justice Dane because I fired up on him and wouldn't let him ask a question.
But you mentioned that numerous times in federal court, there are reductions in sentences without a motion. And I'm looking at the rule. It doesn't require a motion. The language of the rule in federal court does not require a motion for any, it says subsection A, that's for clear error, no motion required. There is a motion required, well, you're saying hearing. You said hearing, I'm sorry.
Yes, sir.
Maybe I just started looking at this for this purpose, but there is no subsection C like we have in our statute that requires, or that you don't think it requires a hearing, but there's language in there that some people think requires a hearing. That's not in the federal rule. That's why there's no hearing.
Right, I agree that the federal rule is slightly different from what we have here, and it is mainly different because in federal court, as Justice knows, judges are assigned criminal cases. And so when they're enacting a Rule 35, it simply comes back in front of them. And that is why I believe, and you mentioned the use of the word state. The use of the word state is mentioned in the second sentence because I believe the General Assembly was trying to pair that with the federal rule. And so ours is slightly different because of rotating judges. And it made clear that jurisdiction is simply in that county, given to that solicitor, not to the Attorney General, and that is how we get to where we're going. It can't be made by the Attorney General.
That subsection C that is raising all the concern here is only a venue?
I believe that, in fact, in the proposed rules, Rule 152, I believe, that it kind of says that this is regarding the rotation of judges so that you don't have a defendant taking his case back in front of a Pickens County judge rather than in Richland County where the sitting solicitor who is elected and in charge of all the criminal cases has the ability to have a say as to whether this person deserves a downward departure or not.
Is it your opinion, or do you have an opinion as to whether or not the requirements of 1725-65 are strict and should be strictly construed with?
I'm sorry.
Complied with, I'm sorry.
My opinion is that the rules of 1725-65 relate to the giving of information which is helpful to the prosecution. The prosecution gets to decide whether it was helpful or not. And in this case, that is why a visit to Judge Manning was had. The recognition of the significance of keeping Mr. Price's identity a secret was made. The judge agreed, and that is why the order was sealed. So I believe that all of the requirements, because I don't believe that 1725-65 requires a hearing, that all the requirements were met. Mr. Price provided that cooperation. It was given to the Department of Corrections. The Department of Corrections has to acknowledge that whether they have a letter or not. And the solicitor acknowledges that by going to see the judge.
If he's so clearly entitled to relief substantively under the statute, what's the harm in sending it back to do it under the light of day?
He is not, and again, I hope this doesn't cut against me, but I don't believe that a defendant is entitled to a reduction. Unlike in federal court, if you have a signed plea agreement allowing you cooperation, I don't believe that a defendant is entitled to that reduction. I believe the apparatus that starts that procedure is the solicitor going to the judge saying, hey, we've got somebody that cooperated, and now we're going to start that process of getting that reduction. If a defendant says, I would rather not have a hearing, I'd rather give it to the judge to give me my downward departure or not, because I need my name to remain secret because the information I gave is against someone in the Department of Corrections who is my roommate, and that person will kill me if they find out, which could happen here. That person will kill me if I find out. I need my identity to remain secret. I would ask not to have a hearing, simply to have my downward departure given by a judge who has the proper authority to do that with the sitting solicitor there.
So to unring this bell and send it back and actually follow the law cannot be done because of potential harm to Mr. Price?
I think that honestly, that sending it back and sending Mr. Price back to the Department of Corrections is like ordering a death sentence on him. I think even the Department of Corrections would acknowledge that it is difficult to keep someone safe after they've told on someone that escaped and was gone for 2 days and could have been gone completely, or could have been sitting in the victim's house, in Jimmy Lee Causey's victim's house, until somebody figured out that he was actually missing. To send Mr. Price back, I believe, is a death sentence, and I believe further would go against the reason for 1725-65 in the first place, which was to encourage cooperation, to give law enforcement another tool, which they did not have prior to this. This is a proposed rule by the Chief Justice at the time, Chief Justice Toll. It was implemented by legislators who have looked at this statute, knew that it had implications on mandatory minimum sentences, including murder, chose not to put that exclusionary language in there because they need cooperation. Law enforcement needs cooperation in order to figure out what's going on, and in this case, as has been stated before, the use of criminals to give good information.
Let me follow up on Justice Kittredge's question. To me, the primary reason you don't want this to go back is because Solicitor Gibson is not going to touch this with a 10-foot pole. He won't start this process if it's remanded de novo, will he? I mean, nobody in their right mind would.
I can't speak for Solicitor Gibson, but I can speak for the fact that anyone that starts this process knowing the information that was given.
All right.
I'm sorry.
I want to dig a little bit into this information. One of the reasons that was attacked, you filed it.
Yes, sir.
To us. One of the reasons was an unsworn addendum that said he told SCDC that an inmate had been gone for 3 days, and SCDC didn't even know. That's one. Nobody from SCDC swore to that. That was just an addendum that Mr. Gibson requested in an email, correct?
That is correct. And
That's an email on the 29th of December.
Yes, sir.
All right, so there's an affidavit from an inmate, and the inmate, I assume, had some credibility issues, with the criminal record that he had. An inmate said, well, I saw Mr. Price do so-and-so and save somebody's life. That was not explored by the solicitor. Bring him in. Let's question him, see whether or not he's telling the truth. The other affidavit was from an individual who was a correctional officer who summarized what somebody else told her she saw, not what the affiant said she saw. Is that right?
That is absolutely
correct. And that's
correct.
all that this whole thing is based on, an inmate's affidavit and a correctional officer's affidavit that's hearsay.
Allow me to differ with you and then and later agree. I think that this is reliant on Mr. Price giving information regarding Jimmy Lee Causey's absence from the Department of Corrections.
Got that.
And that is wholly what this is based on, with the exception of this.
Okay.
Getting information from the Department of Corrections regarding Mr. Price has been next to impossible. In fact, and as an aside, and we talked about my ability to talk on this for hours, I've been working on this, as you could see, for years. Mr. Causey escaped in 2017. The first time Mr. Price gave cooperation to the Department of Corrections was in 2013. My ability, even in looking at it from a legislative standpoint as to what's going on at the Department of Corrections, to get proper information from them, as you can see from the lack of even paperwork regarding an escape, has been next to impossible. And so how it is that an inmate who gives that information, everyone knows he gave that information because, quite frankly, he gave it through me. The Department of Corrections got a phone call. The Director Sterling got a phone call from myself. I just received a phone call from a client. Do you have an inmate missing? Because I have to verify that he does not have this information already. He said, no, I do not. I said, yes, you do. Here's the dorm he's in. Here's the prison that he's in. He's been gone for 2 days, and they just miscount again. And so that's how I verify. I am telling him information that he does not already have. I did not know at that time it was Jimmy Lee Causey. All I knew was that an inmate was missing according to my client.
All right.
Sorry.
Going back to one of the questions about nothing was done, none of the blocks were checked on this statute. I agree with that. Victims weren't notified. No hearing was held. No written motion was filed. And there's one other one, maybe two other ones I can't remember. To me, that goes into the question of void versus voidable. If the order's voidable, I think this is over. If it's void, of course, you lose. So help us out with the very first question we asked, or the Chief asked Attorney General Wilson. How are we to properly hear a motion or a writ of prohibition, petition for a writ of prohibition filed by the Attorney General in these circumstances?
Justice James, I can't tell you how you all can hear a writ filed by someone stepping into the shoes of someone that began the process. What I can tell you is, and again, not to defend the Attorney General or the solicitor, I do not believe the solicitor knew exactly how to proceed given the fact that the identity of the person that had given this information needed to remain a secret.
All right, who made the motion that the order be sealed?
Myself.
Okay, and we know from reading the Judge Manning's handwritten notation that it be sealed, there were no reasons for it. But you're saying that was the reason for it?
Yes, sir.
Safety.
And it was an overriding concern.
All right, let's talk about the sticky note.
Sure.
In normal circumstances, I would assume that the clerk of court receives the order, there's a notation that it be filed under seal, the order's clocked in and literally put in an envelope with that information written, so if anybody opens it, somebody can tell somebody opened it. Was anything clocked in? For example, was the envelope the order was put in clocked in? Or do you know?
I can tell you as a former circuit judge, you know that my ability to find all that out comes at the end of this, and I don't have the answer. What I can tell, Your Honor, Justice James, is that at some point, my office became aware that the Department of Corrections had not recalculated Mr. Price's sentence. So Judge Manning had retired at that point, so I called Judge Hood and said, Judge Manning has signed an order and sealed it. How do I get that to the Department of Corrections? He reviewed it, saw that it was an order to...
That's the March 9 entry?
Yes, sir. He reviewed it, saw that it was an order to reduce a sentence, transmitted that to the Department of Corrections. I then called him back and said, can you reseal it, given the fact that the identity of Mr. Price is a problem at this point?
Okay, so the Department of Corrections accepted an unfiled, unstamped order and released it.
The Department of Corrections accepted an order from Judge Hood. And so I believe that that is why they attached some veracity to the order as it came. But again, I can't speak for them. I can simply tell you that
What do you mean an order from Judge Hood?
meaning that Judge Hood unsealed the order.
No, he's asking you about why the Department of Corrections accepted Judge Manning's unfiled order, and you responded by saying that they acted on an order from Judge Hood, and I'm not aware of any order from Judge Hood other than the March 9 and March 23 notations at the bottom of the December 30 order.
Right, it was an order that was signed and sealed by Judge Manning, opened by Judge Hood, and at that point, how it's transmitted, who it's transmitted to is not within my level of comprehension, but it was transmitted to the Department of Corrections so that they could look at the order, see what Judge Manning had signed, and then have it resealed.
Mr. Rutherford, do you know whether or not this particular order was entered into the file books of the clerk? Because it's not stamped, doesn't mean a whole lot, but if it's filed, it should have been recorded in the file book of the clerk's office.
Chief, I can tell you, I do not know. Again, it just came to our attention that the order had not gone to the Department of Corrections.
But it was in the clerk's of court's office. At least that's where we got it from.
I assume that it would have to be in the clerks of court office. But again, I'm not privy to that information.
But you see the problem there. Like, we can't go around running a justice system by assuming that there are orders. The orders have to be valid and signed and filed, and there has to be some indication on the face of the order that it is a valid order, which is, in most circumstances, the file stamp.
I think that the clerk recognized it being a valid order. I believe that they would have had possession of it because Judge Manning at that point had left the building for all
The
intents and
question is, what you assume and what you believe, with as much respect as you deserve, which is plenty, that doesn't cut it.
Again, Justice Few, we would argue that I don't know whether it was in the clerk's office. I assume that it was because that's where, is my understanding, you all got it. I know that after that, or at some point, it was in Judge Hood's office because that's where the Attorney General's office went to retrieve it. So where it went after it was sealed, I don't know, and nor is it my job to file it. I went in front of Judge Manning with the solicitor. The solicitor laid out the factual circumstances. Judge Manning was swayed by the fact that Jimmy Lee Causey had escaped and that without Mr. Price, Jimmy Lee Causey would still be gone. But he recognized the dilemma in having it out there as to who the identity of my client.
One final question from me, Mr. Rutherford. We gave the Attorney General, some of us, through hardball questions at him and some softies. But we still have this issue of whether or not this matter is properly before this court. And Justice James followed up with that same question. Now, again, I'm going to say to you what I said to him. We're not just trying to resolve this issue for today. Whatever we do today is going to have long-term implications. So now, if we're going to twist ourselves in a pretzel to make this come out right, what are we going to do with the next one? We need some framework to put forth for the bench, benefit of the bench and bar, that they might be able to follow in future cases like this, and I'm certain there will be some. So now my question is, do you object in any form or fashion to the Attorney General's position that he has jurisdiction, or you didn't, that the judge didn't have jurisdiction to hear this matter?
I believe the judge did have jurisdiction to hear this matter. I would agree with.
That's a two-part question.
Yes, sir, and I would
Judge
agree.
didn't have jurisdiction, and we have the right to hear him argue about it.
I agree that the judge had jurisdiction. I do not agree that the Attorney General has the jurisdiction to stand here and argue that effectively he stands in the place of the solicitor and now wants to void a motion that effectively he would have been standing in to have granted. And State v. Morgan, 2002, penal statutes are strictly construed against the state and in favor of the defendant. I don't believe that the state can come in, ask for a motion to be had, that motion is had, the judge signs it, seals it, and then because the state did not do what they were supposed to do, in this case, the Attorney General, acting on behalf of the solicitor, did not do what he's supposed to do, and then come and ask, well, because there's a policy reason out there and people are really upset, I need you all to give me an out. I don't believe that that is a proper course of justice. I do believe that there was a valid reason why the solicitor proceeded the way that he did, why the judge proceeded the way that he did, and because 1725-65 does not set out parameters for how these are to be done, especially when the identity of the person giving the information needs to be kept confidential, that it would help to have guidance from this court or from the General Assembly. But absent that, it was a solicitor acting the way in his elected capacity on behalf of the citizens of his county and on behalf of a victim living in his county as to how best proceed with someone that had given that information whose life would be in jeopardy if he revealed his name.
Was the 19 years a joint recommendation of you and the solicitor, or was that something that Judge Manning came up with on his own?
So as you have been a judge for some time, if you've never appeared in front of Judge Manning as a lawyer, I can tell you that the first thing he asked is, what do you want? And my answer was, I'd like 19. Believing that my work in the federal system, when somebody gives that kind of information, they are typically given a sentence reduction of almost half. that would have
That is
put,
extraordinary to me, because I practice in federal court, criminal law, and if you got a sentence reduction for substantial assistance of this amount, it would be all over the lawyer network, I guarantee you, in the upstate of South Carolina. That's an extraordinary reduction.
I would suggest that Judge Wooten is in the Columbia District, came from Florence. And again, I'm not speaking for Judge Wooten, he's a friend of mine, but routinely, especially if someone testifies, they would get almost half off of their sentence. This was more than half, he had served more than half. And his continued existence in the Department of Corrections would have been a danger to himself and to the Department of Corrections. And the Department of Corrections knew it. The solicitor knew it, the judge knew it, and that is how they acted. And I believe that their ability to keep the information as to his identity a secret is the reason why all of this happened.
When was he sent to New Mexico?
He was sent to New Mexico, and this, again, gets to,
When did that happen?
so it happened several times. And it gets to what I was trying to figure out with the Department of Corrections and their lack of compliance with notice. I don't believe he was properly sent to New Mexico. And in fact, argued that, and they went to pick him up on the state plane to bring him back. And so there are several things that have happened in this case that are revealing to me, in my position and ability to look at what goes on in the Department of Corrections, including the fact that no letters exist in his file as to the cooperation that they know that he gave and the help that he gave to correctional officers while he was president of the Department of Corrections from 2013 up until almost present day.
We've had a lot of discussion here about the difference between subject matter jurisdiction of a judge and authority of a judge. And I just want to clear this up if I can, but I think, and you tell me if I'm mistaken from your knowledge, but until 2010, when 172565 was enacted and became effective, in the state court of South Carolina, there was no subject matter, there was no power, no jurisdiction, nothing, no way that a circuit court judge could reduce a final sentence. Is that correct?
That is not only correct, it mirrors the federal system until 1987 when Rule 35 was amended to allow them to reduce it to mandatory minimums. And in fact, I frequently answer that question by telling people, once your appeal, your PCR is done, there's nothing anyone can do except for a substantial
Right.
sentence.
So if we're having this conversation in 2009, go to a circuit judge. The circuit judge would be correct to say, I don't have subject matter jurisdiction to reduce that sentence.
That is absolutely correct.
And as we sit here today, or more precisely, as you and Solicitor Gibson and Judge Manning sat in the courthouse over there in late December, the only jurisdictional vehicle for doing this is 172565.
I believe that is correct.
All right.
Well, let me follow up then. That's the question I've been trying to get answered since I sat down here. If you are conceding the issue of jurisdiction, and you're also conceding that you've not complied with the statute, 172565, then you out, aren't you?
I don't believe I'm conceding that we did not comply with the statute, and I believe that my statement would be that compliance with the statute is the defendant giving that information and the state going to see the judge to actually make the motion. That the last portion of that statute does not have a time limit. It does not say it's predicate. It does not require that it be done beforehand. In fact, I would argue that it can be done at almost any point except for the 5 days after it is initially filed, that it must be sent to the chief admin judge. But those are requirements on the solicitor, on the state, not on the defendant. And so I don't believe that any reading of this allows this court to penalize the defendant who had no fault in getting this done, did what he was supposed to do under 172565, and is now being asked by the Attorney General to void an order that he himself entered into standing in the solicitor's shoes.
And I didn't take your answers to my questions as conceding the jurisdictional point. I was just trying to make sure I understood what the jurisdictional vehicle is. I get that your argument in response to that is, yeah, that's the jurisdictional vehicle, but failing to meet the requirements in the statute aren't jurisdictional.
That's correct.
All right. Now, you may be wrong on that, but you're not conceding that you lose on jurisdictional.
That's correct.
Any other questions? There being none, thank you, Mr. Rutherford.
Thank you.
Mr. Wilson, anything in reply?
May it please the court. Heather Savitz-Weiss for the state. Your Honor, we became aware, the Attorney General's office became aware that Mr. Price had been released from the Department of Corrections on April 17th of 2020.
But is that relevant at all?
It is relevant because at that time, being familiar with that case, being familiar with Jeroid Price through the appeals and the PCRs, knowing about him being in New Mexico, it became of concern that after 19 years on a mandatory minimum 30 to life sentence, that he had been released into the public. And so the concern of law enforcement, the concern of our office was, how did this happen and did the victims know?
Well, Mr. Wilson answered all those questions very ably and, frankly, somewhat credibly. I mean, it rings true that you guys on the State House grounds where your building is, you didn't know, right?
Absolutely.
Okay, but Mr. Gibson knew because the order said he's sentenced to 19 years and that's how long he's been in jail. So the state knew. The state of South Carolina knew, right?
The state being the Fifth Circuit knew, yes.
The state of South Carolina knew.
Yes, Your Honor.
Okay, and you can tell probably from my questions, that's what I'm struggling with. We've talked a lot about jurisdiction. You say that the threshold jurisdiction does not exist until those blocks are ticked off under 1725-65, correct?
Yes, Your Honor.
But you agree that the Court of General Sessions has jurisdiction in General Sessions matters, has subject matter jurisdiction.
I'm sorry.
Does the Court of General Sessions have subject matter jurisdiction in criminal court matters?
Absolutely.
Okay. And I know that can be finessed and split or whatever, and I understand your position. There's a case called State versus Isaac, 2013, where Judge Newman held an immunity hearing under the Castle Doctrine statute, and he went through the exact proper method of hearing the case, received evidence, and made a finding that the defendant was not entitled to immunity. The defendant immediately appealed, and up to then, the immediate appeals were allowed, but the court disposed of that rule that didn't last very long. In a footnote, they said, acknowledged, it has been settled in this state from an early period that if the inferior court, here the Court of General Sessions, has jurisdiction of the person and subject matter, a writ of prohibition will not lie to correct errors and irregularities in procedure or to prevent an erroneous decision. You're here with a petition for a writ of prohibition, correct?
Yes, Your Honor.
And you contend there are we need to correct errors and irregularities in the procedure or prevent an erroneous decision. That's why you're here.
Justice James, we believe it goes beyond that, but yes, Your Honor.
You have to argue it goes deeper or you lose on that point of law. And what we're all struggling with, I think, is how you get to the starting line.
Yes, Justice James, and that's where I was headed to, was the starting line, and I'm sorry, I started before it.
And I asked a long question, and I apologize.
Nope.
I'll be quiet.
So when we found out, went immediately to the circuit court to find out how it happened, because I think that was the appropriate thing to do. The Attorney General is the supervisor of the circuit solicitors, as this court has the duty to supervise the unified court system and court orders throughout the court system. So as the Attorney General, once we became aware that Jeroid Price had been released after 19 years, first thing we did was we went to the circuit court and said, how did he get released? Said, can't talk to you about it, it's under seal. So went to the public index. There's absolutely no record of any motion, of any hearing, of any discussion of a sentence, of anything, any change, nothing on the public record that we were able to find.
Let me interrupt you just for a minute.
Yes,
I read something from the public index about the order. Was that in there when you looked?
About this order?
Yeah.
Or about me filing to unseal the order?
No. The December 30 order.
It was not in there when I looked.
It was not in there. Because I just printed this out this morning. This is a public index from the Fifth Circuit, Richland County. And it has an entry that says December 30 of 22 at 13:55. and it says order reducing sentence. Now, I don't know whether it's possible to add that later, but to me, this is very important. If it was not, and I'm not really asking you to testify, but you're saying that order was not listed in the public index when you first went to it?
I'm saying when I went to Public Index, I did not see that. And
The entry or the order?
I didn't see anything
Well, of course, there's
since
even
2006.
right. It's your argument that there was no motion in there is important and valid, and I'm just focused on the order. You didn't see an entry for the order.
I didn't see anything past 2006. When the
That's
remitter.
2006.
Yes, sir, Your Honor. And so I talked to the Attorney General, I talked to many people in our office, because this was disconcerting. It was disconcerting to law enforcement, it was disconcerting to the public and the victims, as I said. So I went to the circuit court with the authority of the Attorney General to ask to have that unsealed, just for the Attorney General to be able to look at what was in there. Because I was under the belief, just because of reading the statute, that there would be a motion that would lay out why his sentence was, or why there was going to be a hearing or a decision to reduce his sentence, as well as an order laying out why it was reduced. And I asked to have it unsealed, went with a motion and order to Judge Hood, because I didn't have a motion, I didn't have somebody on the other side. Judge Hood said he was aware of it because of the unsealing back in March, and that Mr. Rutherford was on the other side. We contacted Mr. Rutherford, he said he wanted a hearing, and as your honors know, Judge Hood scheduled a hearing for last Thursday in order to hear this, to see whether we could unseal it so we could look at it and see what was there. This court, fortunately, went ahead and unsealed it before that hearing, and I was able to go and look and see what was there, and I was able to provide that to the Attorney General. Once we looked, there was no motion at all, anywhere. And under Rule 4, a motion has to either be in open court on the record with a court reporter, or it has to be in writing filed with the clerk. There was no motion. And then when I got to the order that we took back, the order was on motion of the defense, and it just mentioned within the order, the matter comes before the court by the defendant through his undersigned attorney, Todd Rutherford, who positions this court to reduce the defendant's sentence. So the order itself started completely against the statute. And the role as the supervisor of the solicitors, it became of serious concern to the Attorney General and to the Attorney General's office.
We understand why you all are interested in this, and it's justifiable. We have no problem with that. We don't quibble with that. We don't quarrel with you with that. We understand the importance of this to your office. But I'm having some difficulty trying to get you to where you are, standing in front of us asking for this procedurally.
Yes, sir, Your
By
Honor.
our rules, by our law. How do you get here? And you made a comment about motions in Rule 4. But you left out the last sentence in that. The last sentence says the requirement of writing is fulfilled if the motion is stated in a written notice of hearing of the motion. Now, apparently Solicitor Gibson and Mr. Rutherford were engaged in quite a few emails. And I'm certain they talked about it then. Would that not qualify as a writing?
No, sir, Your Honor.
Why not?
A written motion of the hearing? There was no written motion
No,
of the hearing.
the rules say if stated in a written notice of the hearing.
There was no notice of the hearing. There was no written notice of the hearing, so that is a third thing.
So
that did not exist.
with Judge Manning is not a hearing in your view?
Absolutely not, Your Honor.
Define a hearing for me.
A hearing is where preferably a scheduled time, but a time where both sides can be heard in front of
Both
the court.
sides were there. Is that not right?
Both sides were there, but based on the statement of Byron Gibson, the solicitor of the Fifth Judicial Circuit, that was a meeting with Judge Manning to decide whether or not this case would even apply to 1725-65.
The notice in that rule that the Chief Justice read contemplates notice to the public and to the victims. at the minimum, correct? And to the press, for that matter.
Yes, Your Honor.
It's an old vehicle that we used to, I mean, I'm surprised to hear that it's even still in use, where you put a caption on it, and you right below the caption, you say, please take notice that on certain date and certain time, the defendant will move before the Court of General Sessions for an order reducing so-and-so. And you take that document and you put it in, as Judge Hill noted, you file it with the clerk's office, it gets a file stamp, it's on there, and you serve it on the other side. And it lets everybody know that there's going to be a hearing. That's what the writing requirement is satisfied by that.
Yes, sir, Your Honor. And as we refer to, there's Rule 29, which is just something that has been talked about as another way that sentences can be reconsidered. And when we talk about that in the context of the Victims' Bill of Rights and the constitutional side, the victims are notified of that there is something going on that may affect the sentence. So the victims, no one, the Attorney General's office, because this was sealed on December 30th, 2022, on the same day it was signed, and it was not filed, it was not in the public index. The Attorney General's office, no one could notify the victims of anything because nothing happened. There was no motion filed to say that there is a reason for a reduction of the sentence, and no hearing was held. There was a conversation in chambers, and going off Solicitor Gibson's statement, that was to decide whether or not 1725-65 applied, and based on that, a motion was going to be filed. And based on the order that is here, it was not the motion of Byron Gibson, it was not the order of Byron Gibson. I know I'm beyond my time, so.
Well, no, we're gonna let you respond. You finish. We want to.
I'd like to ask you, and I'm going to piggyback off the Chief Justice's question, and hate to be a broken record. We understand the equity. We can't use equity to drag you to the finish line and undo this mess. We need a legal basis or principle that allows us to invoke authority to undo this. What is that legal authority?
Justice Kitcher, there is an order by a circuit court judge. As much as I would have liked to, as much as our office would have liked to have made an argument to a circuit court judge, there's an order by a circuit court judge, and under the unified judicial system, this court is the one who is in place to actually have authority over the orders and the integrity of the judgments of the unified judicial system. There is not another judge in the same level would be put in a very dire or very difficult predicament knowing that there was a signed order by a circuit court judge.
Yes, we are here. Yes, we are here to right wrongs. But procedure matters. Getting the case before us in a proper legal vehicle is important. Rules and procedure matter, and I'm just trying to find what is the hook, what is the legal framework or argument that allows us to accept this in our original jurisdiction, writ of prohibition or otherwise. We can sua sponte, convert it to a common law writ, whatever it may be. But what is the legal vehicle that allows us to go back and undo this?
The legal vehicle is Article 5 of the South Carolina Constitution that puts you over the integrity of the judgments of the unified judicial system. There was an order signed by a circuit court judge that on its face did not meet the law as it is in South Carolina. We are bound as attorneys to our oath to follow the rules and the laws as set forth. There was an order, and this is the court where we bring it. And it's under an extraordinary writ because we have a violent defendant who has been released, and it was sealed so nobody could find out about it, and there's nobody's knowledge.
I'm going to have just one follow-up. Mr. Rutherford ostensibly makes a very good argument that on the merits, if anybody was ever entitled to a reduction, his client is entitled to a reduction. And as an adjunct to that, he says, if we undo this, and this gentleman, Mr. Price, is remanded to the Department of Corrections, it's basically a death sentence. What can you, or should we put this on hold until we bring the Department of Corrections in? What can be done to ensure the safety of Mr. Price if we remand him to the Department of Corrections?
Justice Kittredge, there were so many issues with him in the Department of Corrections. He was in New Mexico, in the Department of Corrections in New Mexico, when he made that phone call to his attorney, Mr. Rutherford. There are
So is the answer to my question, send him to New Mexico?
Send him to New Mexico, put him in solitary, send him to New York. There are a lot of things that have happened, and there are a lot of remedies that they have. They deal with very dangerous situations on a daily basis. Director Sterling deals with this on a daily basis. There are ways that this can happen. But just saying we're going to ignore everything that's in the law and let him stay out after being sentenced lawfully by Judge Lloyd to 35 years defies the law and makes everything else an absurdity.
Thank you.
Thank you.
Any other questions? Justice James. There being no further questions, this hearing is adjourned.